Hello, everyone. Welcome to this lecture podcast on trade, commerce, and industrial relations. This is Dr. Manuel Jose Manjo Oison, sharing with you some insights on this topic on trade, commerce, and industrial relations. Let's begin by talking about the importance of this topic. We will recall that at Federation, when the Federation was set up, what the states had to do was actually to surrender and relinquish some of their powers, specifically some of the legislative powers, in favor of the Commonwealth. And so, in other words, prior to the Commonwealth or prior to the Federation, states had already existed. And states, therefore, were both political institutions as well as economic associations. So states, therefore, within states, therefore, there was a lot of trade and commerce going on. And there was obviously a lot of trade going on across states of Australia, or meaning colonies then, as they were then called prior to Federation. And so at the time that there was an attempt to form a federation or the Commonwealth, there were a lot of discussions, negotiations on the extent by which states were to relinquish or surrender some of their powers to the federation or to the Commonwealth. And even now, even when the Commonwealth eventually was created, states continued to be mainly responsible for the welfare of their subjects. And the ability, therefore, of states to be able to take care of the welfare of their subjects would obviously hinge a lot, not only on the powers that they retained, but more specifically in relation to their power to control and regulate the trade and commercial activities within their borders. And that is because as we know, trade and commerce brings in revenues on the part of traders and businesses. And the ability of states, therefore, to control and regulate the trading activities within its borders would determine the kind of revenues they would also generate in the form, let's say, of taxes, or in the form of licenses, or even in the form of fees. And it would also involve questions of what might be permissible and what might not be permissible. There would also be questions of its ability to provide special incentives, for example, to its own subjects in order to invite more businesses or traders in its borders, rather than having these businesses, for example, or traders set up shop and operate in other states. So this is what we will be discussing in this lecture podcast. And part of the questions we will try to determine will be the extent by which, for example, the Commonwealth Parliament is able to regulate trade and commerce, because obviously states have full power to regulate trade and commerce within its borders. But the basic question is, to what extent can the Commonwealth Parliament regulate trade and commerce? And related to that would obviously also be the question of to what extent the states can control or regulate trade and commerce. Does it mean that states can do whatever they like within their borders in relation to trade and commerce and in relation to other activities? There will be questions as well about how permissible is it for states to establish monopolies. And so these are some of the questions we will be looking at in this lecture podcast. And it shouldn't therefore be surprising that many of the conflicts between the Commonwealth Parliament and state parliaments have actually been in relation to trade, commerce, and industrial relations. And there are actually two parts to these conflicts. One pertains to questions about the power of the Commonwealth to regulate trade and commerce among the states under Section 51(1), and the meaning of the freedom of trade and commerce and intercourse clause of Section 92 of the Australian Constitution. The second question relates to the power of the Commonwealth to legislate in relation to domains which typically belong to the states. And in these cases, the question is whether, for example, by using its power under Section 51(1), whether or not the Commonwealth Parliament can then legislate on other fields or subjects that are not within its legislative powers, impliedly and expressly under the Australian Constitution. So what we're hoping to do is that after studying this topic, you should then be able to discuss and explain the power of the Commonwealth to regulate trade and commerce among the states under Section 51 and the meaning of the freedom of trade, commerce, and intercourse among the states guaranteed by Section 92. And in doing so as well, you will also get a sense of constraints on the power of states to actually regulate trade and commerce within their own borders. Secondly, we should then be able to discuss and explain the scope and limits of Commonwealth power to make laws with respect to foreign and interstate trade, make laws with respect to foreign corporations and trading and finance corporations, and to regulate labor markets. So let's begin going deeper now into this topic. So we begin by looking at Section 51 of the Australian Constitution, which provides that the Parliament or the Commonwealth Parliament shall, subject to this Constitution, have power to make laws for the peace, order, and good government of the Commonwealth with respect to trade and commerce with other countries and among the states. Now, we will remember, based on our discussion of last week, that the Commonwealth Parliament only has those powers which have been expressly or impliedly vested in it by the Australian Constitution. So, in other words, every time that the Commonwealth Parliament makes a law, the first question you should always be asking is, does the Commonwealth Parliament have the power to legislate on that field? So in other words, you have always to determine under what head of power in the Constitution, specifically, for example, under Section 51, under what head of power the Commonwealth Parliament is able to make a claim that it can legislate on that subject or on that field. That is crucial, just as a reminder, because the powers of the Commonwealth Parliament are only those that are vested in it by the Australian Constitution, unlike the state parliaments, which continue to have the same powers under the Constitution, even at the time of federation. So under the Constitution, the states were meant to retain and possess the same powers that they had at the time of federation. On the other hand, the Commonwealth Parliament, being a new institution, only had those powers that were vested in it under the Australian Constitution. And because historically, and under the Constitution, states retained the same powers they had prior to federation, what we will have to remember is that states actually had the same powers as each of the states or each of the colonies then had the same powers as the government of Imperial UK. So they had full powers to legislate on anything within their borders, and even to an extent legislate on subjects even outside of their borders if it affected the states or it affected its citizens or subjects. So states had full and broad powers to legislate on anything. Now, on federation or upon federation, states then delimited their powers by relinquishing some of those powers in favor of the Commonwealth Parliament. So the federation was formed, in a sense, at the expense of or by states sacrificing some of their powers in favor of the Commonwealth Parliament. So that makes sense. Because otherwise, if the Commonwealth Parliament were created without powers, then there would have been no reason for the federation. So let's just be clear about that. So whereas the Commonwealth Parliament can only legislate on subjects or fields or heads of power that have been expressly or impliedly conferred upon it by the Australian Constitution, states could legislate on anything, except those which it had then relinquished or surrendered in favor of the Commonwealth Parliament. So having said that, we have to look at Section 51(1) in relation to Section 92, which provides that trade, commerce, and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. And as we will see later on, we begin to wonder whether the notion of trade and commerce being absolutely free is a protection only in relation to states, or does it refer as well to individual traders or even consumers? And that is the subject of a number of cases, ending up in the High Court as well as in the Privy Council, the Privy Council being the previous court of last resort in Australia, until Australia passed legislation saying that all appeals would only be, the final court of appeal would have to be the High Court of Australia. In addition, we will be examining as well Section 99 of the Constitution, which says that the Commonwealth shall not, by any law or regulation of trade, commerce, or revenue, give preference to one state or any part thereof over another state or any part thereof. So the interplay between Section 51(1) and Section 92 raises three constitutional law questions. The first is the power of the Commonwealth under Section 51 subject to Section 92? And that can quickly be answered by noting that under Section 51 of the Australian Constitution, the powers of the Commonwealth Parliament are subject to the Constitution. So in other words, all the powers of the Commonwealth Parliament under Section 51 have to be subject to other provisions in the Australian Constitution. So therefore, Section 51(1), as well as all other subsections in Section 51, must be interpreted and read as being subject to the other provisions of the Constitution, such as Section 91, which guarantees the freedom of trade and commerce across states. Which leads us to the second question: if so, to what extent is the power of the Commonwealth to make laws with respect to trade and commerce among the states under Section 51 limited by the requirement that trade, commerce, and intercourse among the states shall be absolutely free under Section 92? And thirdly, what exactly is the freedom guaranteed by Section 92? So we will examine these questions in this lecture podcast. So the first question that has to be asked is, given that we have Section 92, which guarantees freedom of trade and commerce across the states, the first question is that protection limited to states, or does it guarantee free trade as well in favor of traders? So under the free trade approach, for example, this approach would recognize that the freedom of trade and commerce being absolutely free within Australia would only be limited to the freedom of trade among states. It does not give any specific freedom of trade among traders, individual traders. So that is the free trade approach. That is broad and expansive, because what it says is that while it would not be permissible to severely restrict or impair trade and commerce across states, it would be permissible to severely curtail and restrict the freedom to trade of individual traders or even individual consumers. So that would be the free trade approach. So it provides more power in favor of the Commonwealth. What it means is that under the free trade approach, for example, it would be permissible to set up monopolies. So a state, for example, could set up a monopoly so that traders would not be permitted, traders within its borders. A state may be permitted to set a law, to provide a law that within its borders, its traders are not permitted to sell outside of its borders, or that they will be compelled to sell only to a specific entity within the state. If we follow the free trade approach, that would be legally permissible. On the other hand, if we adopt the individual rights approach, there would be more limitations of the power of the Commonwealth as well as the states to make laws relating to trade and commerce, because under that specific approach, a law, for example, would only be invalidated if there was discrimination between states. Under this approach, even if a law is actually not discriminatory between states or across states, for as long as it is restrictive of the rights of persons to engage in interstate trade, commerce, and intercourse, that law will be invalid. So this approach, therefore, provides a greater constraint on the power of the Commonwealth and on states to make laws relating to trade and commerce. And as we will see, judicial decisions had initially been quite divergent in determining which approach to take in resolving questions relating to the interpretation of Section 92 in relation to Section 51.1. And the High Court in Cole versus Whitfield was forced to state that no provision of the Constitution has been the source of greater judicial concern or the subject of greater judicial effort than Section 92. That notwithstanding, judicial exegesis of the section has yielded neither clarity of meaning nor certainty of operation. Over the years, the court has moved uneasily between one interpretation and another in its endeavors to solve the problems thrown up by the necessity to apply the very general language of the section to a wide variety of legislative and factual situations. Indeed, these shifts have been such as to make it difficult to speak of the section as having achieved a settled or accepted interpretation at any time since Federation. In Miller versus TCN Channel 9 Proprietary Limited, the High Court also said that there is now no interpretation of Section 92 that commands the acceptance of a majority of the court. Now, obviously, this was a prior case prior to Cole versus Whitfield, but the law on the subject has more or less been settled under the case of Cole versus Whitfield. So let's move on. The individual rights approach was actually the preferred approach prior to Cole versus Whitfield, or prior to 1988. And this was the position of the High Court and the Privy Council in the cases of James versus South Australia, and James versus Cohen, and James versus Commonwealth. So in James versus South Australia, for example, the High Court dealt with a South Australian law which authorized the South Australia Dried Fruits Board to control sales beyond the state. And the law also authorized the South Australian Dried Fruits Board to compulsorily acquire certain dried fruits from traders, and for those traders to sell only to the South Australian Dried Fruits Board. Now, this specific law did not actually discriminate between interstate and intrastate trade in dried fruits. The High Court ruled, however, that because the law had the effect of interfering with the freedom of traders or growers to dispose of their products to a buyer in another state, it was held invalid. And for the same reason, when the Commonwealth passed its own legislation trying to control the trade of dried fruits. That same legislation passed by the Commonwealth Parliament was similarly struck down as being invalid and unconstitutional by the High Court in James versus Cohen. Even when an appeal was made by the Commonwealth to the Privy Council, the High Court affirmed the original decision of the Privy Council affirmed the original decision of the High Court in saying that under Section 92 of the Australian Constitution, even if a state law or a Commonwealth law, even if those laws did not discriminate against states in relation to trade and commerce across states, for as long as they restricted or impaired the freedom of traders to trade or to engage in commerce across states, that would be invalid under Section 92 of the Australian Constitution. So in other words, under these three cases, both in the High Court and in the Privy Council, the High Court and the Privy Council adopted the individual rights approach and imposed or read clear limits on the power of the Commonwealth Parliament as well as on the states to legislate in relation to trade and commerce, so that even if a law did not discriminate across states or could not be read as restricting freedom of trade and commerce across states as far as states were concerned, it was essential that the rights of traders to engage in trade and commerce not be impaired. So that is following the individual rights approach. And because of that ruling, when the High Court later on passed the Banking Act of 1947, so when the Commonwealth Parliament later on passed the Banking Act of 1947, which ended up nationalizing the banking industry and prohibited banking by private banks, the High Court ruled that even though that law applied to all states equally and to interstate and interstate businesses equally across states, and therefore it was non-discriminatory in that regard, the High Court ruled that the Banking Act was invalid because following the individual rights approach as guaranteed by Section 92, because it restricted and impaired the ability of banks to engage in trade and commerce and intercourse across states, then the law was invalid. So we will note that even if the law was non-discriminatory across states because it applied to all states equally, the fact that it impaired the rights of individuals, or in this case, the rights of banks to engage, private banks, to engage in trade and commerce and intercourse, meant that the law violated Section 92 of the Constitution. So Commonwealth versus Bank of New South Wales, or the banking case, affirmed the principle that the individual rights approach was the preferred approach in interpreting Section 92 of the Constitution. So in Commonwealth versus Bank of New South Wales, or the banking case, the court said that it might well appear that on the basis of James versus Cohen and James versus Commonwealth, it might well appear that those two decisions were a serious obstacle to the present appellant's case, or in this case, the appeal of the Commonwealth. Section 20 of the South Australian Act was invalid. It was general in its terms. It did not discriminate between interstate and intrastate trade in dried fruits, but because it authorized a determination at the will of the board, the effect of which would be to interfere with the freedom of the grower to dispose of his products, to a buyer in another state, it was invalid. And for the same reason, the Commonwealth Act fell. The court also said that the necessary implications of these decisions are important. First may be mentioned an argument strenuously maintained on this appeal that Section 92 of the Constitution does not guarantee the freedom of individuals. Yet James was an individual, and James vindicated his freedom in hard-won fights. Clearly, there is here a misconception. It is true, as had been said more than once in the High Court, that Section 92 does not create any new juristic rights, but it does give the citizen of state or commonwealth, as the case may be, the right to ignore and, if necessary, to call upon the judicial power to help him to resist legislative or executive action which offends against the section. And this is just what James successfully did. The High Court also said that it would be a strange anomaly if a grower of fruit could successfully challenge an unqualified power to interfere with his liberty to dispose of his produce at will by an interstate or intrastate transaction, but a banker could be prohibited altogether from carrying on his business, both interstate and intrastate, and against the prohibition would invoke Section 92 in vain. Now, the individual rights theory was actually rejected in the case of Cole versus Whitfield. And in that case, the High Court affirmed the validity of regulations made under the Fisheries Act, 1959 Tasmania, which prohibited within and outside Tasmania's territorial jurisdiction the taking, buying, selling, offering, or exposing for sale or possessing crayfish smaller than the prescribed size. So the anomaly here was that it was possible actually for somebody to buy crayfish in another state. And even if the crayfish there, for example, as purchased in another state would be valid, when it was brought over to Tasmania, because the crayfish did not meet the requirement as to size under Tasmanian law, then that person, the trader, would have committed a violation of Tasmanian law. And the claim, therefore, was that that law violated Section 92 of the Australian Constitution, and following the rules of the High Court and the Privy Council in James versus South Australia, as well as James versus Cohen and James versus the Commonwealth, which espoused the individual rights approach. The law of Tasmania, therefore, in particular Fisheries Act of 1959 Tasmania, was invalid for violating Section 92. However, in Cole versus Whitfield, in that case, the High Court unanimously rejected the individual rights theory and any test that distinguished between permissible and impermissible restriction of interstate trade. For the High Court, the crucial point that needed to be determined was whether or not a law imposed an unnecessary burden on interstate trade and commerce in relation to states. So if there was a discrimination on trade and commerce affecting states, even if in that case the law would therefore be invalid. But if a law still permitted trade and commerce to be unrestricted across states or between states, even if there was a burden on individual traders, that law would remain valid, because the only burden that would be impermissible as far as the Cole versus Whitfield case is concerned, or was concerned, was a discriminatory burden of a protectionist kind. So this would mean that prohibited discriminatory and protectionist burdens might mean the increase of price of foreign goods and non-tariff barriers such as quotas on imports, differential railway rates, subsidies on goods produced, and discriminatory burdens on dealings with imports. So for as long as a law, under the ruling in Cole versus Whitfield, for as long as a law was non-discriminatory across states, even if a law may have imposed a burden on individual traders, the law will be valid, because the only discrimination that the High Court was prepared to strike down under Section 92 would be a discrimination that affected states themselves. And in this case, it would relate to the laws that states would pass that would interfere the freedom of trade and commerce, in the sense that it would have imposed burdens on interstate trade and commerce. So following the decision of the High Court in Cole versus Whitfield, it was then quite not surprising. It was no longer surprising that when a law was passed by the state of New South Wales, whereby it created a trading monopoly, which then enabled the Barley Marketing Board to compulsorily acquire all barley grown in New South Wales, effectively creating a monopoly over that produce. The High Court upheld that New South Wales legislation. So even if it was restrictive of the freedom of traders, because then traders in New South Wales could no longer freely sell their produce, their barley, to traders outside of New South Wales, the law was held to be valid, because that specific law was actually observed regardless of where the trader was from. So it was a law that applied equally both to intrastate trade as well as interstate trade. And the High Court, therefore, having previously rejected the individual rights approach, said that characterized the New Zealand South Wales law as not being protectionist and not being discriminatory because of its equal application to all traders. So the High Court also said that Cole versus Whitfield decided that the freedom of interstate trade and commerce guaranteed by Section 92 is freedom from imposition on that trade and commerce of discriminatory burdens of a protectionist kind. A law will discriminate in the relevant sense against interstate trade or commerce if the law on its face subjects that trade or commerce to a disability or disadvantage, or if the factual operation of the law produces such a result. What this essentially means is that it is possible that a law on its face may actually appear to apply equally to traders, whether interstate or intrastate, and so therefore not be non-discriminatory. But if by the application of the law, there would actually be some sort of discrimination because the operations of some traders in other states would put it at a disadvantage. So the effect of the law being discriminatory would then have the effect of making that law being invalid. And we will see this more clearly when we come to the case of Castlemaine versus Castlemaine Tooheys versus South Australia. Now, before the case of Cole versus Whitfield and the case of Barley Marketing Board, most of the cases had focused on the question of protectionist burdens in relation only to traders, but not to consumers. The High Court was then confronted with looking at the application of Section 92 on its effect or its impact on consumers. And the case that arose was that of Betfair versus Western Australia, where the question was whether or not the restriction and the guarantee of freedom of trade and commerce across states under Section 92 also applied to consumers and not just to traders. And in Betfair, the problem was that the law passed by Western Australia regulated out-of-state betting exchanges as well, because the rule was that under the Betting Control Act of 1954, out-of-state betting exchanges were required to get a license from the Western Australian government. So in Betfair, the ability of consumers to place bets, for instance, through out-of-state betting exchanges, which Betfair was actually able to provide, was restricted as a result of the Betting Control Act of 1954, Western Australia. Because under that specific law of Western Australia, betting through a betting exchange and the publication inside and outside of Western Australia of a Western Australia race field could only be made with an approval under the Act. And the Act, however, legally prevented Betfair from covering Western Australian races without publishing Western Australian race field. But the attempt on the part of Betfair to secure an approval to publish the Western Australian race field was denied, because according to Western Australia, it was against its regulations to allow betting through betting exchanges. So it disallowed the request of Betfair to publish the Western Australian race field. In raising its complaint to the High Court invalidated provisions of the Western Australian Act because it had amounted to a discriminatory burden on interstate trade of a protectionist kind. So the High Court ruled that the law burdens interstate trade and commerce both directly and indirectly. It does so directly because it denies to Betfair use of an element in Betfair's trading operations. It does so indirectly by denying to Betfair's registered players receipt and consideration of the information respecting the latest Western Australian race fields by access to Betfair's website or by communication with its telephone operators. So these effects of Section 27D1 of the Western Australian law operate to the competitive disadvantage of Betfair and to the advantage of RWWA and the other in-state wagering operators. The law in its application to Betfair answers the description of a discriminatory burden on interstate trade of a protectionist kind. The High Court had the opportunity to examine the notion of a burden of a protectionist kind in Castlemaine-Tuhis versus South Australia. The South Australian government passed legislation for the purpose of improving conservation efforts and recycling efforts. And under that legislation, it did two things. One was that it required a higher deposit to be made when somebody purchased beverage using using bottles that were non-refillable. And if a refillable bottle was used, a lesser deposit was made. But that specific rule applied to everyone who were supplying beverages. So whether, even if their beverage was actually imported from another state, it applied equally to that state. So there was no question that that law had equal application in South Australia. At the same time, the South Australian law required or created depots where people could return their bottles. There were more opportunities for buyers of beverages using refillable bottles to return them and get back their deposit. Whereas if a consumer purchased a beverage using a non-refillable bottles, there were fewer depots for this. And the Castlemaine Tooheys, which was affected by the law, brought a complaint before the High Court questioning the constitutionality of that act. And it argued that whilst the law had equal application on its face, it actually, in its effect, created a discriminatory burden of a protectionist kind that was already disallowed by the High Court in previous cases, such as Betfair versus Western Australia, as well as Whitfield versus Cole versus Whitfield. And so it said that that law was invalid because it was a discriminatory burden of a protectionist kind, in that the bottles that Castlemaine Tooheys had were actually non-refillable. And because they were non-refillable and they were producing this outside of South Australia, the effect was that consumers were forced to pay a higher deposit for consuming its products. And secondly, they had fewer depots to go to for the purpose of returning their non-refillable bottles and then reclaiming their deposit. The High Court ruled in Castlemaine Tooheys versus South Australia that it was actually permissible for states or even for the Commonwealth to pass a law that would discriminate or even impose a burden on interstate trade. So the mere fact that a law may actually discriminate across states, and the fact that it may impose a special burden on trading or on intercourse and commerce would not by themselves alone invalidate a law if there were rational and legitimate grounds for the discrimination and the burden that were imposed by legislation. What was impermissible what the court called relevantly discriminatory measures. So if there are rational and legitimate grounds where, for example, such as the need to regulate interstate trade and commerce, and the regulation may be because of security measures or to provide safety or quality standards or to protect the interests of consumers concerning pricing, for example, or the efficacy of certain goods, then there would be a valid ground for discrimination to be found in the legislation. And that alone, the fact alone that a legislation or a law may be discriminatory and be protectionist will not invalidate the law if rational and legitimate grounds existed. But it will not be sufficient, however, even if a law even if a law were to be valid because it discriminated and it was protectionist in a sense, but because it had rational and legitimate grounds for such discrimination and for such protectionism, still that law would fail if the main purpose of the legislation was actually to be protectionist in a state. So if the main purpose of the law was actually to protect the industries or traders of a state, that would invalidate the law if that is the main purpose. So the protectionism and the discrimination must only be incidental to the main purpose of the law being to achieve an objective that is legitimate, which is about conservation, for example, or safety or the welfare of the subjects of the state. So secondly, not only must the burden be incidental to the achievement of the legitimate aims of a law, but the measures that were used in achieving the law's aims must not be disproportionate to the measures. So the measures must not be disproportionate to the achievement of the law's aims. So in other words, it was important that in achieving the law's aims, the measures would not have been disproportionate. So if, for example, the purpose, what the law intended was to, for example, in the case of Castlemaine Tuhis, if the purpose of the law was conservation, and by seeking to promote conservation, it looked at regulating the use of bottles, whether or not they were refillable or non-refillable. So in the case of Castlemaine Tuhis versus South Australia, the High Court saw that the South Australian law, in requiring a higher deposit for non-refillable bottles, was actually disproportionate to the aim of the law, which was conservation, mainly because, in the first place, Castlemaine Tuhis was not producing its bottles in South Australia. It was producing it in another state. And so even if that law were there, it had no effect on conservation because Castlemaine Tuhis would continue to produce non-refillable bottles, and it had no impact on the conservation that would happen within South Australia. The High Court also required that it was essential to ask whether or not there were actually alternative means of securing that legitimate object. So in this case, the High Court was asking whether or not there were some other way for South Australia to be able to achieve its conservation goals without having to require a higher deposit for non-refillable bottles, or for it to have provided fewer depots for the return of non-refillable bottles. So that was another legitimate question. So to summarize, the question is, what must a law satisfy in order to avoid being relevantly discriminatory? So the first is that the law must be necessary or proper and appropriate and adapted to a legitimate object, that is, either to the protection of the community from a real danger or threat to its welfare, or to the enhancement of its welfare. Secondly, the burden placed on interstate trade must be incidental. So the aim of the law should not be to impose a burden. So the burden should only come as an incident to the law trying to achieve a legitimate object or purpose. But if the purpose of the law itself is actually to provide a burden, mainly to be able to protect its own industries or its own subjects, that law would then be invalidated. Thirdly, the burden on interstate trade should not be disproportionate to the achievement of the legitimate object. So there must be a proportionality between the measures that are being sought to be implemented under the law, as well as the achievement of the legitimate object. And fourthly, the question has to be asked whether or not there are other reasonable, non-discriminatory alternative means of securing the legitimate object. Because if there are other alternative means which are non-discriminatory, then it would suggest that the purpose of the law would be to effect a prohibited discrimination. Now, let's examine the notion of interstate commerce. So under Section 92 of the Constitution, that provision guarantees not only freedom of interstate trade and commerce, but also freedom of intercourse among the states, which under Section 92 must be absolutely free. And if we speak of intercourse, we look no longer at this point just at trade and commerce, but for example, passage or transport or even communication across states. Is that freedom guaranteed? So, for example, the question is, would it be permissible for a state to impose border controls? Would it be possible for a state to control internet access? And so on. So these questions would be covered by Section 92. And it leads us to that basic question. If a state or the Commonwealth were to impose a restraint or a burden, would it be relevantly discriminatory? Or would it be permissible? And by applying, for example, the Cole versus Whitfield test. And is the question, and it also raises the question of whether or not, if the freedom is available under Section 92 in relation to interstate discourse, is that freedom absolute? And the High Court ruled in Nationwide News versus Wills that the guarantee of freedom of interstate intercourse is not confined to the physical movement or carriage of goods or things among the states, and it encompasses all of the modern forms of interstate communication. So now we will move on to Section 5120 of the Australian Constitution, where it provides that the Parliament shall, subject to this Constitution, have power to make laws for the peace, order, and good government of the Commonwealth with respect to foreign corporations and trading or financial corporations formed within the limits of the Commonwealth. And the first question we have to ask is it necessary for a corporation to be covered under subsection 20 to be established solely for the purpose of trading? And the High Court ruled that the answer that the High Court answered that question with a no, so that a corporation may actually be set up for a different purpose. It could be for the purpose of promoting football or even basketball. And so therefore it is not really a commercial venture in the sense that it seeks to create profit through its trading. But if the result of the activities of the corporation were that it actually engaged in trading or trading activities because it had sales and engaged in marketing activities, then in that case, it would be possible for that corporation to be considered a trading corporation if its trading activities were a substantial and not an insignificant part of its operations. And this was the ruling of the High Court in R versus Federal Court of Australia, ex parte Western Australian National Football League. So in that case, Chief Justice Barwick said that the description trading corporation in Section 51, subsection 20 must be given its full content generously rather than restrictively construed. And a corporation formed within the limits of Australia will satisfy the description trading corporation if trading is a substantial corporate activity. Now, this is crucial because a law may be passed that regulates activities of trading corporations, and it might be possible, as happened here in this case of R versus Federal Court of Australia, ex parte Western Australian National Football League. It may be possible that when a corporation was established, it was not established as a trading corporation, and the purpose of that corporation was not really for trading. And so a corporation may say that they are not covered by a law that applies to trading corporations because it is not a trading corporation in the first place. But the High Court has ruled that even if a corporation was not established as a trading corporation in the first place, if its activities are substantially in trading or involves trading, then it can still be considered a trading corporation under Section 51, subsection 20, and therefore be covered by a law that applies to trading corporations. So in that case, a trading corporation may also be a sporting, religious, or governmental body. As long as the trading is not insubstantial, the fact that trading is incidental to other activities does not prevent it being a trading corporation. So a law that applies to trading corporations would apply also to corporations that are not essentially, in terms of its purpose, trading corporations. It would apply to those non-trading corporations for us if their activities were also substantially in trading as well. The question also can be asked whether or not the corporation to be covered under subsection 20 must be established for the purpose of finance. So for example, the State Superannuation Board, the purpose of the Superannuation Board was to provide superannuation benefits to its contributors. And obviously it was not intended to be engaged mainly in trading. However, it also engaged in trading activities in the sense that it entered into commercial and housing loans. And in the case of State Superannuation Board versus Trade Practices Commission, the High Court ruled that just as a corporation may be a trading corporation, notwithstanding that its trading activities are entered into in the course of carrying on some primary or dominant undertaking, so also with a corporation which engages in financial activities in the course of carrying on its primary or dominant undertaking. So thus, a corporation which is formed by an employer to provide superannuation benefits for its employees and those of associated employers may nevertheless be a financial corporation if it engages in financial activities in order to provide or augment the superannuation benefits. So going back to subsection 20, subsection 20 applies to foreign corporations as well. What do we mean by foreign corporations? So for it to be considered a foreign corporation, it means that it should not have been formed within the limits of the Commonwealth. So it has to be formed outside the limits of the Commonwealth. So it has to be formed in America or New Zealand or China, for example. Secondly, it must be a corporation. So in other words, the law that the Commonwealth passes must apply to a foreign corporation and not another entity. So it must not be in relation to a sole trader or a partnership. It does not have, there's a requirement that the foreign corporation has to be in trading or financial corporation. It's sufficient that it is a foreign corporation. And what is the essential test of whether or not it is a corporation? What it means is that the entity that is formed is one that has a corporate personality separate and distinct from its shareholders. So in other words, that entity, being a corporation, has the power to enter into contracts on its own, the power to enter into loans on its own, the power to file suit on its own, apart from its shareholders. And secondly, it also means that the assets of the corporation and its liabilities are distinct from the assets and liabilities from its shareholders. So if a corporation had a loan, for example, that loan of the corporation is not a loan of the shareholders. And neither would the loans of the shareholders be the loan of the corporation. So even if a person who owns 99% of a specific corporation, let's say, has a loan of $100 million, that loan would be the loan only of the shareholders of the shareholder and not be the loan of a corporation, because the corporation has a legal personality that is distinct and separate from its shareholders. The rule under subsection 20 of section 51 is that while the Commonwealth Parliament has the power to pass laws pertaining to foreign corporations and trading or financial corporations, the Commonwealth Parliament has no power to control the incorporation of companies. So while it may control matters such as the duties of directors or the duties of shareholders, or it may control issues about reportorial requirements concerning documents or concerning the activities, both marketing and financial activities of corporations, the Commonwealth Parliament is not permitted to pass legislation that involves the incorporation of companies, because under subsection 20, that specific subsection says that foreign corporations and trading or financial corporations formed within the limits of the Commonwealth. So the assumption being that under subsection 20, the corporation must have already been formed within the limits of the Commonwealth, meaning that they subsist. So in other words, if the law passed by the Commonwealth Parliament pertains to the formation of a company or a corporation, that would not be permissible under the limiting clause of subsection 20. The final point that we need to examine in this lecture podcast would be the industrial power of the Commonwealth Parliament under section 51, subsection 35, which provides that the Parliament shall, subject to this Constitution, have power to make laws for the peace, order, and good government of the Commonwealth with respect to conciliation and arbitration for the prevention and settlement of industrial disputes extending beyond the limits of any one state. So if you look at the provision closely, it concerns conciliation and arbitration, and that conciliation and arbitration must be for the prevention and settlement of industrial disputes. So the first question we can ask is, would it be permissible for the Commonwealth Parliament to pass a law that prescribes the industrial rights and obligations of corporations and their employees and the means by which they are to conduct their industrial relations in general? So in that case, it does not even have to involve an industrial dispute. Secondly, would it be permissible for the Commonwealth Parliament, for example, to legislate in relation to minimum terms and conditions of employment that cover such matters as rates of pay, maximum hours of work, and leave entitlements, which matters fall clearly outside of section 51, subsection 35? And the answer is yes. This was the ruling of the court in Re Pacific Coal Proprietary Limited, ex parte Construction, Forestry, Mining, and Energy Union, where the High Court said, no doubt, that the power conferred by section 51, subsection 20 of the Constitution extends to the regulation of the activities, functions, relationships, and the business of a corporation described in that subsection, the creation of rights and privileges belonging to such a corporation, the imposition of obligations on it, and in respect of those matters, to the regulation of the conduct of those through whom it acts, its employees and shareholders, and also the regulation of those whose conduct is or is capable of affecting its activities, functions, relationships, or business. So in other words, following the provision of subsection 20 of section 51, and this time not on section 51, subsection 35, using its corporation's power, the Commonwealth Parliament can actually enact legislation relating to wages of employees or their industrial rights and even the obligations of corporations. So in that case, the power of the Commonwealth Parliament to legislate relating to minimum terms of and conditions of employment and even concerning rights and obligations of corporations and their employees may be based on subsection 20 of section 51, or under the corporation's power of the Australian Commonwealth Parliament. More importantly, following the engineers' doctrine, the expansionary consequences of the engineers' doctrine, it would be permissible for the Australian Commonwealth Parliament to legislate in matters relating to rates of pay, maximum hours of work, and leave entitlements, if in doing so, that same law also talks about industrial disputes and conciliation and arbitration. So for as long as the Commonwealth Parliament passes a law on arbitration and conciliation with respect to industrial disputes that involve interstate matters or going beyond the limits of any one state, then it would be permissible for the Commonwealth Parliament to then legislate in that same law pertaining to minimum terms and conditions of employment that may cover such matters as rates of pay, maximum hours of work, and leave entitlements. And this was the ruling of the High Court in New South Wales versus Commonwealth of Australia, or the work choices case, where the High Court ruled that by using Section 51, it can broadly legislate on industrial relations and employer-employee relations beyond the limits of Section 51, subsection 35, but more importantly, as broadly recognized by the High Court in the engineer's case, it can expansively, therefore, legislate on the basis also of subsection 35 and subsection 20 of Section 51. Which means that in that case, the Commonwealth Parliament has the broad power to legislate generally on the industrial relations of constitutional corporations. And when we speak of constitutional corporations, we are essentially speaking of corporations that fall within the ambit of subsection 20 of Section 51 of the Australian Constitution pertaining to trading or financial corporations formed within the limits of the Commonwealth. So after studying this topic, you should then be able to discuss and explain the power of the Commonwealth to regulate trade and commerce among the states under Section 51(1), and the meaning of trade and commerce and intercourse among the states guaranteed by Section 92, and discuss and explain the scope and limits of the Commonwealth power to make laws with respect to foreign and interstate trade, make laws with respect to foreign corporations and trading and finance corporations, and to regulate labor markets.